Good afternoon, everyone. I just came by. I'm Jane Harmon, and President and CEO of the Wilson Center, former 9-term member of Congress, former Senate staffer who was chief counsel of a subcommittee that looked at access to the law 100 years ago, at which point I bonded with the then leadership of the ABA, especially Chesterfield Smith, whom some may remember, who was an awesome president of the ABA, and have held it close ever since. As a recovering lawyer and a recovering politician, which is a lot to recover from, I still think lawyers matter, and I still think process matters, and I absolutely know that at a time when Congress is at a fairly low ebb in terms of its productiveness, and the executive branch is claiming more and more authority under Article 2, the courts are absolutely necessary, and the Supreme Court and other courts have moved into a vacuum and have asserted more authority. So I think this conversation's important. I know that Aspen has paired with the ABA to do this for some years. I don't know how many years, but I remember introducing it last year. And I think the panelists that you have selected all have a very relevant background. Susan Block happens to be someone I've known for a long time, and I am hopeful that this conversation gets everyone more informed. I know the media is part of it too, about what the challenges are for the court and what the challenges are for the bar, and what the challenges are for the country as we contemplate a very uncertain world where a major reason why hopefully we will someday, hopefully soon, win the argument in this era of terror challenges against us. I don't think it's a war. I think it's an era. Someday the way we will win the argument is by living our values. And if you ask me, what is our number one value in this country, it is the rule of law. And we abandon that at our peril. So I just wanted to come down and say hello, and I'll catch up on what happened later. But I hope we keep this pairing going for many years. It's very important to the Wilson Center to have an affiliation with you and to worry about educating the public on critical issues, and especially how the Supreme Court term might turn out, and especially now. So thank you very much, and I apologize, John, for being a bit late.
No worries. Thank you, Jane.
Well, thank you very much, Jane. We truly value the relationship we have with the Woodrow Wilson Center and the great work you're doing here. So thank you for those words. So let me, on behalf of the ABA, welcome you all to the ABA Division for Public Education's On the Docket Supreme Court program, hosted in partnership with the Woodrow Wilson International Center for Scholars. I'm Gary Slayman. I'm chair of the ABA Preview Advisory Board. Preview is a flagship publication of the ABA Division of Public Education, and for decades has been the only resource to provide detailed analysis of each case before the Supreme Court prior to oral argument. Each preview issue highlights the main issues before the court in a way that is easy for non-lawyers and lawyers alike to understand. The Preview Board is delighted to welcome you to On the Docket, the Division for Public Education's annual Supreme Court panel. We're excited to be hosting this program once again in partnership with the Woodrow Wilson Center. Today we've assembled a great panel. Jane mentioned it, and I'm going to let John introduce it. But the purpose of the panel today is to help us better understand the significance of the October 2012 term and give us an inkling of what and how some of the headline cases for the upcoming term might play out. Our moderator will introduce each of our panelists, but let me just say something about John. John Milewski is a veteran broadcast journalist and communications professional. He has extensive experience as a moderator, an interviewer, anchor, reporter, and producer. He's currently the host of the award-winning radio and television program Dialogue, a production of the Woodrow Wilson International Center for Scholars. John is a regular help to us in these endeavors and does a fantastic job. And I just want to thank you again, John, for your generous support for our programs here at the Center.
Thanks. The fact checkers are going through my introduction right now just to make sure. Well, welcome everyone. This is of the hundreds of panels that I am involved in moderating throughout the year. The ABA panels are among my favorites, and I'm not just doing the old Hollywood, Las Vegas type. I love this man. Let me embarrass. I really mean it, and one of the reasons is because of the quality of the panels that they assemble. You're going to really enjoy this. These people are so good that we may have to charge you for tuition before the night is over. That's how much you're going to learn. So let me, you have programs, and I hope you picked up a copy of Preview, which Gary just mentioned. Let me give you, from your left to right, introductions of each of our panelists, the brief version for those joining us via the internet and via MHZ networks. Susan Lowe Block is a professor of law at Georgetown University Law School, and once upon a time she served as a law clerk for Justice Thurgood Marshall. David Salmons is a partner with the law firm Bingham McCutcheon, where he chairs the appellate practice group. Previously, he served as an assistant to the Solicitor General of the United States and has argued 14 cases before the Supreme Court. Adam Liptak covers the Supreme Court for the New York Times. He was a finalist for the Pulitzer Prize in 2009 for his series on the American legal system and comparing it to other systems around the world. And Stephen Wormiel is a fellow in law and government at American University's Washington College of Law. He's co-author of a biography of Justice Brennan and was the Supreme Court correspondent for the Wall Street Journal. Please welcome our panel to the discussion. We're going to begin with a look back before we look forward. It would be impossible to ignore that previous Supreme Court term. It says it right here, a historic year for the Roberts Court. You know they can't print this stuff if it's not true. If the Supreme Court were a television program, I don't know, this is like Who Shot JR. We ended with a real cliffhanger of where we're headed in the next term. So let's just begin with your general thoughts. A lot of the conventional wisdom is there are hard feelings left over from the way things transpired, a lot of soap opera. Others have said, look, people are in this for the long haul when you're a Supreme Court justice, so you can't afford to hold grudges because you need that vote next time around. We'll go through each of the panelists in order of introduction and get their thoughts on where the dynamics of the Supreme Court sit as we begin a new term. Susan.
Well, as John mentioned, I did clerk for Thurgood Marshall. It was a while ago. But the 9 justices view themselves really as a family, and it's actually a sort of lonely job in a sense. They're fairly isolated, and they spend a lot of time together. So it's an unwritten but very devoutly held belief that they are family, and so they rarely. That's at least the court that I knew, and from what I know about the current court, this was not always true. They weren't always that collegial, but. This court, they do respect each other. So it sounds like, from the vantage point of court watcher, which we all are, that it was a tense last few weeks of the court, and I believe that was true. But I would just be shocked to hear that there are hard feelings when they come back this week or whenever they're going to come back for their piles of cert petitions. They really are grown-ups, and they.
So the partisanship that has engulfed the town and the country, you don't think has made its way to the court? It still is, as you describe it, family? Hatfields and McCoys, or what family I guess we're talking about?
One point I just want to make, and then I'll stop. But Scalia, his best friend on the court is Ruth Ginsburg, and they spend all their New Year's together as the two families, the two couples, and. Go to the opera, and they couldn't be more politically different and ideologically different, and that is not that unusual. So.
David.
Yeah, I agree with everything that Susan just said. So this is going to be a boring panel, I guess. But I would add one caveat though, and first let me just reiterate that these justices know how to work with each other. That they've got stable relationships that. Aren't going to be upset by differences in any particular case. I think for those of us that watch the court closely, last term followed some traditional patterns. There were a certain number of close cases, 5-4 cases. Of those, Justice Kennedy still was predominantly the deciding vote. contrary to what some people often assume, in 5-4 cases, they were about equally divided last term in terms of whether Kennedy joined the more conservative bloc or the more liberal bloc of the court. It's just that some of the cases got more media attention than others. But if you look across the board, including in some very significant criminal procedure and criminal law cases, Justice Kennedy joined with the left side of the court with some frequency last term. I think one of the interesting dynamics to watch is that both sides, at least the partisans out in the world that watch the court, hope for someone on their team to step up and be a sort of Kennedy whisperer, someone that can help Justice Kennedy in the close, controversial cases to kind of woo them over to one side or the other. Whether anybody is particularly effective at that or Justice Kennedy is particularly subject to such influences, I think is very debatable. But I think that's one of the things you sort of look to in the dynamics back and forth. It's not so much the personal relation, which I think remains strong, but the question is who is going to be most effective at helping Justice Kennedy and maybe influencing Justice Kennedy in close cases. My own view is if you look at the court on the left, there was a real loss when Justice Stevens retired in that role. I think Justice Stevens was very skilled, and you could see it during oral arguments. Many of the questions seemed to be directed at Justice Kennedy and helping him see things in a particular way. It's the oral argument is one of the main ways in which the justices actually communicate with each other about their views in a case, and so it plays a critical role. I think many on the left have hoped that Justice Kagan would step more into that role. And I think if you look at the first couple of terms now that she's had, you'd have to give her pretty good marks, and you'd have to think that maybe there's real reason to be optimistic that she can be influential. One of the indicators for that, I think this last term, was that in the area of juvenile punishment, which is an area that's been very close to Justice Kennedy's heart over the last several terms, Justice Kennedy actually was the leading justice, the senior justice in the majority, assigned it to Justice Kagan to write, and she wrote one heck of an opinion. Regardless of how you think about that issue, I think it's the most persuasive opinion that's been written in that area, which suggests some trust developing between them. At the same time, you'd have to look at the relationship perhaps with the Chief Justice, who the right probably hopes has the most skill sets at sort of being the Kennedy whisperer on the right, and think that perhaps that relationship and that role is going to be a little more difficult going forward in light of this last term.
You said they're not going to hold grudges over particular opinions on any individual case, but what about, will they hold any grudges over the one version of what happened is that Justice Roberts, Chief Justice Roberts, made a last-minute change in spite of urging from his colleagues on the right that he stay with the majority, or what they intended to be the majority. Do you give any credence to that story? And if so, would there be any grudges held over process, a sense that the rug was pulled out at the last minute? See, since you're going to agree, I've got to try to stoke the fire.
Sure. It's difficult to know exactly how these things play out. They don't really give you a roadmap as to how they reach their decisions. I think many have looked at the opinions and have concluded that the dissent, the joint dissent, which itself is a pretty unusual thing to see. Typically, dissents have authors. Typically, dissents are directed at the majority opinion and take it on head on. This opinion did not. Was at one point at least intended to be the majority opinion. It repeatedly refers to Justice Ginsburg's concurring opinion as the dissent. That's another pretty good indication that might be so. I'm fairly persuaded that that's the way the process played out. I think the only real open question is how much of that, what became the joint dissent, was actually authored by the Chief Justice himself at some point, if he had assigned the opinion to himself and then decided to change positions, and that's very difficult to know that. So I think there's a fair amount of credence to the idea that there was movement among the opinions, and probably relatively late in the process. I don't think that's that unusual, and I don't think it's the kind of thing that in and of itself would injure the relationships among the justices. I'm sure, again, I think the one thing that was a little different about last term It's not that there was changes. It's not that, the justice changed their mind. It's that Justice Kennedy, not just that he was in the dissent, it's that he had sort of gotten himself to that point where he sometimes seems to in his jurisprudence, where he's ready to save the republic. And he's sort of on a fairly moral high ground in his mind, and he has this really essential role to play, and he was denied the opportunity to play that because of what happened. My own guess is that will have some impact, at least in the way in which they influence each other. I don't think it's going to be a sort of personal animosity, but that was a little different. I don't think we've seen Justice Kennedy lose the opportunity in his mind to save the republic when a terrible thing was about to happen, and that seems to be the tone he had in his opinion, which I thought was interesting for him not to be able to have his will come through in that instance.
Adam, you've had some time. I'm sorry, Susan.
I was going to say, right after he made the cover of Time magazine as the decider.
Yeah. Adam, you've had some time to sort this out?
So, I mean, that is the story of the term, and maybe we should just review the bidding for a second. I think you all know this, but on the last day of the term, Chief Justice Roberts surprises everybody by being the fifth vote, joining the four liberals to uphold the health care law. The people who saw that coming are lying. Everyone had... I rest my case. No, really, the idea that there are people in the land who predicted that on the theory that the Chief Justice adopted, he would be the bare fifth deciding vote, joining the liberals with Kennedy on the other side. Perhaps Susan was there. I don't think so. But anyway, that's just by way of background. So
We'll do
you
a full investigation.
so you have a very surprising result, and it means that the usual paradigm of how you think about the court is where's Justice Kennedy, and David gave a very nice account of that, is not the right way to think about the most important case of the last, pick a number, large number. We have a big surprise from the Chief Justice who by background and by jurisprudence and by his experience on the Supreme Court and as a lawyer in the Reagan administration gave all the signs of being a reliable movement conservative vote. And when the second President Bush put him on the Supreme Court, everyone breathed a sigh of relief, and they thought, well, at least John Roberts is going to vote our way. And on this one, he didn't. I think had he been appointed to be Associate Justice, which was where he was initially appointed to be, to replace Justice O'Connor, you might have had a different vote from John Roberts. But here you saw a Chief Justice, not an Associate Justice, who took into account perhaps not just how he might like to have voted, but also the prestige, authority, integrity of the institution that he's the custodian of. And in that role, he saw fit to do this surprising thing. And now the question is, what's the aftermath of that? I believe there was a sense of personal betrayal in the court. I don't think it was a last-minute switch so much as what's on the face of the opinion, which is he subscribed to that view that everyone thought was the deciding factor in the case, which is the health care law justifiable under Congress's power to regulate commerce? And he says no. And so there are 5 votes for that proposition that in the legal academy was thought to be frivolous. And the predictions were 8-1, 7-2. Nobody takes the Commerce Clause seriously. And very, very few people predicted there would be 5 votes to strike down the law under the Commerce Clause. And then he flips the other way on the tax power, which got almost no attention during the argument, vanishingly little attention. And so we have this very surprising outcome. My guess is that at conference, when the justices first deliberated, he announced that he was with the conservatives on the commerce power, assigned the decision to himself, and lo, many weeks later, the draft circulates and he lives up to that promise, but he surprises people with his move the other way. So now the question is, in light of the very harsh response the Chief Justice got, both through leaks from the court and in the press, whether that affects his basic outlook, because I don't know that federalism is his core concern, but the things he really cares about, among them race and campaign finance and criminal procedure, is this going to in some way move him off of those points and move him more toward the center of the court and leave Justice Kennedy on the sidelines? I don't think that's likely, but it does affect the zeitgeist to an extent. I think it was a wrenching moment for the court. They are, some people say, in an arranged marriage with no possibility of divorce. So they do have to try really hard to get along. It's foolishness not to get along. But you also have a sense where people on the right are still shaking their heads and saying, I can't believe John Roberts did this to us. The theory that he cooked up is, they say, hard to justify. Charles Fried, one of the, who was Solicitor General under Ronald Reagan, and in the end thought that the statute should survive, did something interesting. He was the one guy in the history of the umpire metaphor. You know, when Roberts was on at his confirmation hearings, he says the judge is like an umpire. And ever since then, there have been countless people who have sort of tried to recast that metaphor. And Fried does something, I think, very good. He says, here's what happened. He called a ball a strike. He called a strike a ball. But at least the runner was safe at first. But in doing all of that, he, Roberts really sowed some turmoil in the landscape, and how that will play out going forward, very interesting.
Adam, it's always risky business to get into guessing motivations, but of all the analysis and speculation that you've heard, what's the best theory you've heard on what was the motivation?
I think it would have been very troubling. We have, for the first time since at least the 1930s, an ideologically divided court where all the liberals were appointed by Democratic presidents, all the conservatives by Republican presidents. So you had Bush v. Gore ideologically divided, but not divided in that partisan sense. You had Citizens United ideologically divided, but not divided in that partisan sense. If you had a partisan division, 5 Republicans versus 4 Democrats striking down a Democratic president's signature legislative achievement, that would have sent a message that the court is a political institution, and I don't think John Roberts wanted to send that message.
Stephen.
I want to take a slightly historical look at something that we've been talking about. You know what I think that Republican conservatives really want, what they really long for, and why there's frustration here, is they want what the Warren Court had. There was a period from about 1963 to 1967 or 68 in which the liberals on the Warren Court pretty much had 5 votes to do anything they wanted. And conservatives, ever since the moment Ronald Reagan was elected, so 32 years ago, have been waiting for that moment, waiting to have 5 votes to do anything that those 5 wanted to do. And it's positively mind-boggling to them that they haven't been able to get there in spite of God knows how many Supreme Court appointments by Republican presidents. And so I think that the frustration at the end of the term was partly that frustration bubbling over, that here was the moment where it seemed like there were 5 justices appointed by Republican presidents and the biggest law that anybody cared about in a long time, and here it is. This is the perfect storm moment, and it didn't come out the way they wanted it to come out. Somebody was obviously very angry. I don't know who it was. I don't know whether it was another justice, as the reporting said it was, or whether it was law clerks. My instinct is, as with others, that will pass. I think the court is to some degree accustomed to having tense months of May and June. There are always more 5-4 decisions that are closely decided and often resolved at the last minute at the end of the term. And so there's always tension and frustration at the end of the term. Was this greater because the stakes were higher? Sure. But will it pass, or has it already passed over the summer? My guess would be that it has. I'm not sure that there was talk about Anthony Kennedy being frustrated if the chief changed his mind. There's probably nobody on the court that's changed his mind more often in big cases, from what we can tell from looking at the working papers of the justices in recent years, than Anthony Kennedy. So if he's the one who's so frustrated, take a look in the mirror. How many times has he done it? And nobody was ratting him out by leaking frustrations in public. I mean, I think if there hadn't been the leaks, we would have thought, okay, big case, surprising outcome, next term. The leaks kind of changed the dynamic and left everybody scratching their heads and saying, well, what's really going on here? And I think it's just going to blow over and the court will go back to being about its business.
Stephen, you began with the notion of a historical context, and historically speaking, is this court more or less predictable than courts have been?
It is less predictable, I think, than the analogy I used of the liberals on the Warren Court. The liberals on the Warren Court had their ideological differences. In First Amendment cases, you had Justices Black and Douglas who had an absolutist view of the free speech clause, and that made it difficult for the majority to coalesce around a free speech principle, but they did it. So the unpredictability was really only how are they going to get there, not were they going to get there.
But was the Warren Court, historically speaking, the rule or the exception? Is predictability the rule or the exception?
I think predictability is probably the exception. I think the court is I'm one who believes that the court really decides cases as they come, and not in kind of statistical probabilities that would tell you the outcome ahead of time.
Two things. One, to now not agree with everybody, let me just say that I think that political narrative that Adam laid out, while in many ways is sort of the conventional wisdom of how it played out, I have a very difficult time accepting that that's in fact the way that it played out. And I think you sort of have to take the Chief Justice at his word. He found the argument that it was a tax to be persuasive. What's interesting about that is the debate about whether it was a tax or not existed apparently primarily only in his own head, because if the dissent, I don't mean that to minimize it, but if the dissent was originally the majority opinion, Justice Ginsburg's concurrence was the dissent, that opinion at no point objected to the fact that this was permissible under the taxing power.
But by stressing
So
this
it
taxation
was-
argument, did the Chief Justice, in a sense, fix the legislation on behalf of the Obama administration? I mean, that's certainly the result.
I think that goes to whether you find his argument persuasive as to whether it in fact, it is a tax. It's an odd position, I think, in many ways. It doesn't go down smooth. He doesn't apply, the Anti-Injunction Act that normally would apply to taxes because he says Congress didn't intend it to be a tax. But it's sort of an accidental tax. It turned out to be a tax after the fact, and therefore it can be upheld as such, which is a rather, I think, unusual position. But I would just add one substantive point of law about that. We'll see what happens in the future if you take the Chief Justice at his word that his sort of analysis of what makes it a penalty, what makes it a tax, has to do with sort of its size in part and how coercive it is. I think most people who have looked at the healthcare law think that eventually, in order for it to be effective, that number is going to have to go up substantially because it is in fact not high enough to create the kind of incentives that they intended to create under the Act. If it does go up and a case comes back, we'll maybe have an opportunity to find out whether the Chief Justice really meant what he said about what the line is between a tax and a penalty. Until then, I want to give him the benefit of the doubt. I would just say this. This is not a case that, the healthcare case was not a case where the Supreme Court was inserting itself into a political case. Congress passes what is a very controversial law. It's challenged by 26 states and scores of other entities and individuals. The lower courts are divided on whether it was permissible and how to construe it. The Supreme Court had no choice but to grant review in that case and to render its decision. It was not doing politics, it was doing law. And I would just point out that some of the cases that some people like, you could make a different argument about. Take, for example, the enemy combatant cases and the Guantanamo Bay cases where you have both political branches that has worked out some sort of a compromise as to the process that's going to be afforded detainees. There was no circuit conflict there. The Supreme Court grants review and overturns that balance that was struck by Congress and the executive twice. During a period of ongoing some type of hostility, whether you want to call it a war or not. That is the court being very comfortable, I think, in the exercise of its role, regardless of the political implications. I have no reason to think all of a sudden they chicken out because there's an election and it's an important piece of legislation. That doesn't make any sense to me.
Okay.
This is a court that's not afraid to exercise its power. And if his intended goal was to minimize the political influences of the court and on the court, I think this is going to backfire terribly if that were the case, because again, I think there was a lot of political pressure brought to bear on the Chief Justice. If the lesson taken away is you can get them to blink, you're not going to get less of it in the future. Every case that has any political implications is now going to be, oh, this dire thing for the Republic could be the Supreme Court has to back down. So,
Susan, you've been patient here. I know you're dying to get into this discussion. And then Adam, I want to ask you a question as well, since the gauntlet was thrown down.
I just wanted to make two small points. One was that I think John Roberts was influenced a bit by not wanting the court to be as political as it was getting a reputation for being. But I actually, one of the reasons why I predicted the outcome, I didn't predict all the nuances, was the court is supposed to defer to Congress if Congress comes up with a program that can fit within the Constitution. The court is not supposed to judge policy, and the court is not supposed to really make sure Congress dotted every I and crossed every T. I got that right. So I think on the merits, John Roberts really believes that Congress has the power to have a health care law that involves the private sector, that is not a government program totally like something like a public option would have been, or no, public finance. What's the word? The government does everything. Anyway.
single payer.
So
Single payer.
payers. Sorry, and that was everyone agreed they could do single payer. So Roberts said, well, they could do single payer. They can do it this way too. And the other point I want to make, and then I'll be, is that when we talk about the court being predictable or not predictable, we're always looking at actually a very small slice of the court. It's about 20 to 30% where they divide 5-4. On the rest of the docket, they're pretty united.
As we were in chambers before we began this, one of the things we discussed is the gravitational pull of the Affordable Care Act discussion and debriefing it, and how in the terms of a preview we could spend a lot of time looking back, which is what's happening to us, but we're about to make a correction. But before we do that, Adam, I have to ask you, since you and David presented different scenarios of how things may have played out, do we ever really find out for sure?
Years later.
How many years later? How long does it usually take?
Well, you have the kind of Jeff Toobin, Jan Crawford kind of book, which can come out only a few years later. You have the Steve Vermeil kind of book, which does really detailed reporting
way later
on Justice Brennan. It tends to come out in books, and of course papers are released over time. So we have the Blackland papers are out now.
So eventually we will know.
I did want to say a quick word in response to David.
Please.
Of course.
Which is that having disagreed with my premise, everything he said seemed to support what I was saying, that he found the tax argument implausible and yet the chief embraced it. He seemed to suggest that there's reason to think the chief responded to some political pressure. The notion that he endorsed the policy outcome is belied by the decision itself, where he says it's not for me to say. That's, we defer to Congress because they know better than we do. And even in discussing this tax argument, he said, I'm not saying it's the best argument, I'm just saying it's plausible enough for me to defer to Congress. All of that, I think, is consistent with the Liptak view here.
Okay.
Yeah, and I would just say,
In a second, we're not going to. Okay, quick.
I think our disagreement is maybe slightly on the positive, what actually happened. I think it's very hard to tell. I'm going to take him at his word, what influenced him. On the more normative, which I thought I heard in your comment a little bit, that it was sort of, that what he did reduced the political footprint of the court and made the court seem less political. My view is if the court, in a case like that where it has no choice but to grant review, if it wants to do law and not politics, what it has to do is do law and do it persuasively. And you can judge for yourself whether the opinion does that or not. But I don't think, I think if the goal was to reduce the political role of the court and the influences on the court, it's going to backfire.
Okay, when Stephen, when your new book comes out in 10 years, then
we'll have an answer.
Then we'll have the answer. Let me shift gears slightly before we take a look at what's coming up. The other thing that we could talk about is the context under which this term will be held. It's a presidential election. And we have a couple of justices, at least one who will become 80 years old during the next administration, and maybe two, I think, if my math is correct. do voters think about Supreme Court nominations when they cast their votes? In other words, is this a factor in the Obama-Romney equation? Stephen, let's begin with you.
You know, it's not getting that much attention so far. I think it is an important issue that voters ought to think about, but I don't think it really makes that much difference in the outcome of the election.
Adam, what do you think?
I agree with Steve. I think it's sadly a low salience issue because there's almost nothing a president does more important than appointing a Supreme Court justice. And in a way, that's a testament to the fact that the issue that has kept the Supreme Court front of mind in previous decades has been abortion, and we don't have any abortion cases in the pipeline.
So I'm tempted to ask this audience if they care about this as a campaign issue, but their mere presence here might indicate that this audience is not a representative sample. So, oh, what the heck? How many of you will take the possibility that the next president, the probability that the next president will get a nomination or three? How many of you put that on your short list of priorities that will influence how you cast your vote? If you put that high on that list, raise your hand, let us take a look. The cameras record the vote. How many of you don't? How many of you are in this category that it's far down the list? Yeah, again, I predicted this audience is out.
For whatever it's worth, I was listening to a recording of comments by former Justice Souter this morning, in which he said that one survey shows that 2/3 of the American people don't know that there are 3 branches of government. So I don't think
Which
this
would mean
audience
that,
is typical.
Yeah, that would certainly prevent you from making it a priority if you don't know it exists. David, what do you think?
You know, this is way outside of my area of expertise, so I don't know. My own guess would be that for those voters where it would make a difference, they already know who they're voting for and have already made up their mind. It's an important factor, but you've already figured out which team you're on generally before you get there, I think.
Right. Susan, good point.
I don't think it matters to most people, but there was a button, I think, during the Clinton election that said, "It's the Supreme Court, stupid." And
Well, does it have any impact on the court's behavior? In other words, I'm not suggesting they'll play to votes, but what I'm asking is, will it affect what types of cases they will listen to or arguments they will listen to before the election versus after the election? Are they sensitive to the political environment in that way?
they, no, it
No.
won't affect
Okay.
what cases they hear or when they hear. And one good example of that, and I'll be brief, was again in the '92 election when the abortion issue was, the parties wanted that on the docket early so that if they were going to overturn Roe versus Wade, they would do it before the election. And in order to facilitate that timing, what the parties did is filed their petition for certiorari much earlier than they had to. And all of you who are lawyers know you rarely file anything before you have to. So that was a very concerted effort to manipulate the court in a way. And the court knew it was being used in that way, but it didn't react in the sense that it didn't delay things. It just went on the parties' timetable, even though the court knew why the parties were doing that. I don't know if they made that clear.
You did. Any other thoughts on this?
And I would just say if it were true that the court was that sensitive about it, we would now be anxiously awaiting the January 2013 arguments over the Affordable Care Act. They wouldn't have heard the case last
Good point.
term. They would have put it off.
I can think of a counterexample, which is the court had the opportunity to revisit Citizens United, and there were 4 votes to go the other way, and 4 votes is typically enough for the court to hear a case coming out of Montana. The case, had cert been granted, would have been argued right around Election Day, and I think the court thought better of doing that.
Okay. Now,
I would just add one quick
were
thing,
gonna
which is that I think it's interesting that even in the context where we have a president who's been pretty open in his criticism of the court in certain respects, and perhaps has had as adversarial a relationship with the court as an institution as we've had in a while, it's still not very much of a political issue in this campaign at all, it would seem. So.
well, what we're going to do now is there's a format we established a couple of years ago, and it seems to work very well, is we've asked each of our panelists to look at a case or a couple cases and provide you with a brief overview of what the justices may be opinioning And in some cases, we know that these cases have been scheduled. In others, they might be. So we're going to go through that right now. And Susan is going to go first. She's going to talk about an affirmative action case, Fisher versus University of Texas, Austin, and tell us a bit about that.
Well, this is the court's been wrestling with the affirmative action issue for years. It sort of started in the 1970s. And initially, the court's reaction to it was to try and avoid it. So they would deny cert, or they would find the case moot, or they just didn't want to handle it. Finally, in 1978, they did decide what is called the Bakke case. It was a very splintered decision. Turned out Lewis Powell, Justice Powell's opinion, decided the case, but he really only wrote for himself. At the end of that case, what we knew was that 5 members of the court at the time said that schools could consider race when they are admitting students to their program. These are all cases of university or law schools or medical schools, not lower schools. And you could consider race, but you couldn't have a formula, you couldn't have a quota. And so after the Bakke case, schools affirmatively adopted affirmative action programs, trying to model it as best they could on Justice Powell's opinion. In the early 2000s, a case came out of the University of Michigan, 2 cases actually. One was a program that the law school had adopted where they considered race when they were admitting students, but it was just one factor in many, and there was not a formula. And the court found 5-4 that was constitutional because it was sort of nuanced enough and not a quota or a formula. The undergraduate program out of the University of Michigan was also challenged and heard on the same day. And that was struck down because the court said the undergraduate program, just by sheer numbers, couldn't do, or said they couldn't do, the nuanced approach. So they actually had a formula where you got so many points for being a trumpet player and so many points for being a lacrosse player and so many points for being black and so many points for being something else. And that the court said, no, you can't do it like that. It's just too crude and it's not nuanced. Okay, that brings us to what did the University of Texas do? Because that's the case that we're now going to be hearing next week, or 1st of October, beginning of October. Texas at first had a program that considered race, and it got struck down by the Fifth Circuit. It never reached the Supreme Court. So the Texas program gets struck down. It can't have an affirmative action program. So it adopts something called the 10% rule, where any student who graduates from a Texas high school in the top 10% of his or her class is automatically admitted to the University of Texas. And because Texas's public school system is so highly segregated, black high schools and white high schools, that 10% rule got the University of Texas a diverse class. Because if the top 10% of everyone in every high school can go to Texas, that automatically gets you diversity. And that's the program Texas has had all along. Then after the Michigan case, and the Supreme Court said, well, no, it's okay, you can consider race as long as it's nuanced, Texas added on to its program. It still has the 10% rule. But it wanted to also get a more selective class and, again, a more diverse class. So it started to consider race in the part of the class that is being filled not by the 10%ers. So that's the question. Can the argument that schools use and that the Supreme Court has accepted as a compelling governmental interest to justify using race, because we obviously don't like to consider race if we don't have to, but if there's a compelling governmental interest, then, and you have a narrowly tailored program to accomplish it, that makes it constitutional. The issue in the Texas case is they didn't, what they're claiming as their compelling governmental interest is have a diverse student body. and have diversity in all the classrooms and diversity, school-wide. The problem for Texas is the 10% rule accomplishes that. So they have a little bit of a harder time saying why they need to consider race for the other part of their class. The lower court upheld the program. The Supreme Court is going to hear it. Kagan will not be participating because she was involved in the case when she was Solicitor General. So that leaves 8. That leaves the 4 very conservative members of the court. Their view is you just can't consider race. As John Roberts said, the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. You just can't do it. That's 4 votes. The 3 liberal justices plus Kagan, but as I said, Kagan's out, generally are sympathetic to these affirmative action programs. So they're likely to approve. So once again, Kennedy is going to be key. And because there are only 8, there's the possibility of a 4-4 split, in which case the case has no precedential effect. Decision below stands, which means Texas can keep its program, but it has no precedential effect. That's one possibility. Another possibility is that some of the justices may find that this plaintiff, Abigail Fisher, she's suing for herself. It's not a class action. She's the only plaintiff. She doesn't want to go to the University of Texas anymore. She's going somewhere else, and she's not seeking admission. All she is seeking is her $100, the money she expended on the application. So she just wants the $100. So there's a good possibility the Supreme Court says, and I think Texas has agreed to give it to her. So it just may be, it's just, why are we spending all this time and money and upsetting the whole apple cart for this one person who doesn't really care? And it's just, So they could find it moot. They could also find she doesn't have standing because maybe she wouldn't have gotten in anyway. And that's the liberals' dream, is to get rid of this case because Texas does not have a very powerful justification for the program.
What I'd like, just in the interest of time, what I'd like to do in these cases where each of you do a presentation is have the others on the panel just quickly offer a sentence or 2 observation, tips for court watchers, predictions, anything that you see fit that you think would be relevant.
So 2 quick points. Those problems with the case, the mootness, the standing, are real problems, but they were there when the court decided to take the case. And if that was going to be how the case goes off the rails, I don't know why the court took it in the first place.
You only take 4 to...
The
four who don't like it.
The reason the court took it was because there's been a key shift since the Michigan case that Susan mentioned, which was written by Justice Sandra Day O'Connor, a 5-4 case. Her seat is taken by Justice Samuel Alito, who's one of the conservative justices Susan mentioned. Anthony Kennedy, while he can be a little soft on these things, has never in his life voted to uphold an affirmative action program. So the reason they took it is there are 5 votes to do something significant here.
Stephen or David, any different thought?
I think the narrowest possibility that saves affirmative action is that the court, by a 5-3 vote, says when you already have a diversity plan in place, you don't need the extra diversity plan. Using race on top of a program that's already achieving diversity bears an even higher burden. We can strike that down without eliminating all affirmative action. Or they may go all the way and overrule past cases.
The parties are asking to overrule the Michigan cases, the Michigan law school case.
Yeah, the one piece I would add is that while Adam's absolutely right, Kennedy has tended to vote against these kinds of plans. He's also seemed to have embraced the Bakke, Justice Powell compromise, if you will, and hasn't wanted to overturn that apple cart completely. So I think those that are sort of looking to this to really make a sea change here and perhaps prohibit it across the board, my guess is they're going to be disappointed.
But recall that he dissented in the Michigan case.
I think the tension that really comes out of Grutter and Gratz, if you care about doctrine a little bit, is that on the one
Michigan
hand,
cases.
I'm sorry, that's right, the Michigan cases, is that on the one hand, it's supposed to be a compelling interest standard. You're using race. That's supposed to be a pretty strict level of scrutiny. On the other hand, especially Justice O'Connor's opinion, talks about deference to education decisions in such a fulsome way that it's hard to see how it's anything still resembling the traditional compelling interest. And I think you might see a rebalancing of the level of deference that you get that comes out of it. But I would be surprised, for example, if the Bakke compromise is still left in place.
Okay, I need your help, or your memories, because thanks to a typo, I don't necessarily have who is going to talk next about gay marriage and the Defense of Marriage Act petitions. Was who?
I hope it was me.
I hope it was you. I'll take
We're
anyone.
all
Adam.
hoping it was you.
Unanimous vote.
So just yesterday, Justice Ginsburg announced what everyone knows, which is this coming term, which already has this first blockbuster that Susan talked about, will have a second one, almost certainly. Not yet, but you can almost take it to the bank, that the court will consider what many people think of as the great civil rights issue of the day, which is same-sex marriage. But they'll consider it probably not in the context you've been following it. You may well have been following the case filed in California by the celebrity team of Ted Olson and David Boies, who want to take on full throttle, straight ahead, whether the Constitution guarantees a right to same-sex marriage, even in states that don't want it. Let's put that case to one side. That's the Prop 8 case. We have a much more nuanced set of cases that are very likely to reach the court involving a federal statute called the Defense of Marriage Act, 1996, signed by Bill Clinton, which I think he regrets, which did two things. And here again, I'm going to tell you one thing and ask you to forget it. One of the things it did was it said states don't have to recognize same-sex marriages from other states. Fine, that's not an issue in this case. What is at issue in the case is whether federal benefits must follow state decisions on who's lawfully married. So if people in Massachusetts, same-sex couples, are lawfully married, does the federal government get to discriminate and say, I'm going to give federal benefits to lawfully married opposite-sex couples, but I'm not going to give federal benefits to lawfully married same-sex couples? And the Federal Appeals Court in Boston, the First Circuit, has said no, struck down a federal statute. That is a big deal. So if a federal statute gets struck down, that by itself makes it very, very likely the Supreme Court will take the case. It also helps that every side of the case, and the Obama administration is sort of on both sides at once, wants the Supreme Court to take the case. The Obama administration's current position is that it will continue to enforce the Defense of Marriage Act. It won't give people these benefits, but it will not defend it in court because it believes it to be unconstitutional. So the Defense of Marriage Act in this setting, very likely to reach the court. There's a complication. The best case is this First Circuit case, but there's reason to think that Justice Kagan has to be recused because she may well have worked on it as Solicitor General and refers to it in her responses to Senate questions at her confirmation hearings. That makes the Solicitor General and others that has been peppering the court with other possible vehicles, other possible cases to get this issue before the court. Unfortunately for them, there's not been another appeals court decision, so they're using an unusual procedure of asking the court to take a case directly from the federal trial court level, the federal district court. So which case they take of these DOMA cases, open question. That they take it, very likely. If they take it, are there 5 votes? This is probably this is definitely a case where Justice Kennedy is the decisive vote, and it is the kind of case where his instincts might be in favor of this relatively small incremental step toward, call it marriage equality. He was the author of the 2 leading gay rights cases that the court has heard. And then let me just say, the Prop 8 case, the Ted Olson, David Boies case, is also up for grabs at the Supreme Court. That has a bunch of complications in it. It may be that the court is not ready to jump feet first into this issue, but might rather, most likely I would think, hold the case while it decides the DOMA case and then send it back down to the lower court for a little more cogitation. It could also conceivably simply decline to take the case, but that would mean that there would be marriage equality in California. And if the nation's most populous state allows gay people to be married, that would be a further step gay rights advocates would be very pleased with, because it would help normalize this that status. And when the court eventually reaches the issue, gay rights advocates would be much happier if the map that they're looking at doesn't just have 6 jurisdictions that allow same-sex marriage, but as when the Supreme Court struck down bans on interracial marriage, a much larger number.
Any thoughts from our other panel? Stephen?
Well,
Yes?
I mean, there's a staggering point in there if it plays out this way, which is that if the court takes the First Circuit decision, the Massachusetts decision, you could end up having the federal government required to pay benefits to gay couples affirmed by an equally divided court, if Kennedy votes with the liberals.
This is just not the sort of issue I think an 8-justice court wants to decide. Right? So I think there's reason to think they take one of the others.
I have a question. If she's recused because she considered this issue in the First Circuit, why are the other cases? I realize she didn't participate in them, but it's the same issue.
Her practice, and I think this is a widespread practice,
Talking about Justice Kagan here.
is the rule is if her fingers touch the particular case, the somebody versus somebody else, she'll stay off. But issues come up over and over again in all kinds of permutations and contexts, and the fact that you once worked on the issue in some general sense as a government lawyer doesn't mean that you're recused from it forever. Although I don't know that's my speculation, grounded in some reporting, and I think that's how it plays out in this case. But different justices probably have different practices.
That's my general understanding, too.
I agree with you, Adam. I just don't think it makes sense. But
Wouldn't be the first thing.
Next up, and again, my bungled score sheet here, I have you down for Stephen batting third, playing first base, and talking about voting rights. Is that correct?
That's it. You've got it.
Okay.
Your notes are good. So if Adam was talking about the great civil rights issue of this era, I'm going to talk about one of the great civil rights issues of another era, the Voting Rights Act. The Voting Rights Act was passed by Congress 47 years ago, 1965, and was designed to deal with systemic attempts in many parts of the country to keep African Americans from being able to vote. One provision of the Voting Rights Act, Section 2, basically applies to any effort to change voting laws or adopt voting policies with the purpose of discriminating on the basis of race. Like Adam, I'm going to ask you to forget about that part. That's not the issue that's coming before the court. The issue that I want to talk about is one that the court has not yet agreed to hear. Like the marriage cases, there are cases pending, but the court hasn't agreed to decide them yet. Section 5 of the Voting Rights Act took about 7 or 8 southern states and counties and cities and said that because their efforts to prohibit African Americans from voting in the 60s were so egregious that in those jurisdictions, if they made any change in their voting laws or policies, they had to pre-clear, that's the legal term, they had to get approval from the Attorney General or from a 3-judge court in Washington before they could adopt any changes in their voting practices, in order to have those practices reviewed to make sure that they were not having the purpose or effect of discriminating on the basis of race. Again, that was 47 years ago. Congress has repassed that provision numerous times. In 1982, Congress passed that provision again for 25 years. And in 2006, Congress passed the provision yet again till 2031. Now, the interesting question here, if the court gets into this, which we think it will, is a kind of clash between old civil rights law that was critical to making sure that people had the right to vote and new federalism law in which state and local jurisdictions are saying this law is outdated, intrudes significantly on our self-governance, the ability of states and counties and cities to govern themselves, and doesn't pass constitutional standards. That's the simple version. It is actually a very complicated subject, and I don't want to get us too deeply into the weeds because we'll get lost and never get out. But let me make a couple more points quickly. The issue arises not in a total vacuum because the Supreme Court 3 years ago took a case that raised many of the criticisms of the Voting Rights Act that are now being raised. The case has the kind of unappealing name of Namudno versus Holder. Namudno stands for Northwest Austin
Municipal Utility
District. It was a Texas utility district that ran its own voting system and fell under this pre-clearance provision of Section 5. It wanted to take advantage of a part of the law that allows any jurisdiction theoretically to opt out, to say, look, we've had a long track record of not discriminating on the basis of race. It's time for us to no longer have to go through this pre-clearance. The Northwest Austin District said we want to do that. There's no evidence that we're discriminating against anybody. They were told by the lower federal court that they were not the right kind of jurisdiction to be able to opt out, that it had to be a state. They took that up to the Supreme Court. The Supreme Court, in an opinion that expresses broad concerns about the continued vitality and constitutionality of the Voting Rights Act, nevertheless decided not to decide that issue. The case basically did two things. It told the Northwest Austin District, yes, you are a jurisdiction that can qualify to opt out. Now go back to square one and apply to opt out. We're not going to decide whether you should. We're just going to decide that you can be that kind of jurisdiction. But in the meantime, it was like an engraved invitation on fancy stationery to Congress, because page after page of the opinion says this law may no longer be supportable. The kinds of voting rights violations that occur in the country today may no longer justify this intrusion into the functioning of state and local governments. It says it over and over and over again. It's really like an engraved invitation to Congress to do something. Well, that was 2009. Now it's 2012. Guess what? Congress didn't do a thing. And so there are now numerous cases making the same kinds of challenges and coming back to the Supreme Court. The court already has two petitions in front of it, one from a small county in North Carolina. The case is called Nix versus Holder. They wanted to change their local elections to nonpartisan elections. They're in a jurisdiction that has to be pre-cleared. The Justice Department refused to pre-clear them because there's some evidence that in some places changing from partisan to nonpartisan may actually have the effect of decreasing representation for African American and other minority votes. So they appealed. In the meantime, while they appealed, the Justice Department decided to go ahead and pre-clear them and allow them to make the change. So the Court of Appeals found the case moot, but because they want to get this issue before the Supreme Court of whether Section 5 is constitutional or not, they, rather than going back and making the change, they've appealed to the Supreme Court. That doesn't strike me as a great vehicle for the court to reach this constitutional issue, because they also then have to talk about whether it's moot or not. The other case is Shelby County, Alabama, which didn't actually try to bail out of the process. and apparently, at least according to the lower court, didn't try to bail out of the process because it had actually made several changes in its local election laws without seeking the approval of the Justice Department. In other words, it didn't comply with pre-clearance requirements. And so the assumption is, at least the court's assumption was, they didn't seek to bail out of the process because they knew there was no possibility that they would get approval for that, having essentially defied the pre-clearance process. So they're now coming to the Supreme Court challenging Section 5 as well, saying it interferes unduly with our ability to engage in self-governance, to run our own election system. And so the court could choose one of those two cases. There will also be other vehicles coming along. Everything that's going on in the state of Texas, both the redistricting after the 2010 census in Texas and the Texas voter ID law, which has been challenged. Both of those involve pre-clearance as well, and those cases are just about at the Supreme Court, if not already there. So if the court doesn't like the two petitions it already has because of the mootness problem, or in the case of Shelby County, because Shelby County actually didn't do anything to trigger this case, the court could wait for the Texas case. There's also similar South Carolina issues coming along. The ultimate bottom line question, and then I'll stop, is a federalism question in a sense. The Supreme Court has said, this was a kind of great project of the Rehnquist Court, the Supreme Court has said that when Congress uses its power to try to remedy constitutional violations, Congress's power is actually much more limited than Congress had previously thought, and Congress has to stick to a kind of tight fit that the nature of the violation justifies the nature of the remedy. If we're experiencing substantially less race-based voting discrimination today than we were in the previous times that Congress renewed this law, then Congress's authority for renewing this law is much more limited. It's much more restricted, and the law may not really be justified in its present form. The counter-argument is that this is still one of the great civil rights laws of our time, that to the extent that we have made progress in race discrimination in voting, the court itself admits in the opinion 3 years ago that that's probably in large part because of the effectiveness of this law.
Okay, thank you. We time for very brief comments if you'd like to make them. No? Thanks for the thorough job. And David has the unenviable task, and thank you for volunteering to do this, of covering more than one case, sort of 3 cases in 5 minutes. Going to be talking about a torture case, a copyright case, and for you outdoor enthusiasts, say Arkansas Game and Fish.
Well, I'm going to mix it up a little bit, actually, and throw a little bit of. My task was we were out of sort of politically charged cases and really interesting cases at that point. And so my task is to sort of walk you through a few of the other cases that are before the court this term that have interesting legal issues in them. So put your law geek hat on. Fortunately or unfortunately, the Supreme Court is full of 9 law geeks themselves. They love these kinds of cases. The press tends to cover more of the really politically charged stuff. I think the Supreme Court's at its best when the politics are gone and they're just working on a very difficult statutory or regulatory question. The amount of preparation and the hard work and the analysis they bring to bear on that's incredibly impressive. Let me just walk through a few. So there, in the context of criminal cases, there are a couple of interesting cases out of the state of Florida. Florida versus Jardines and Florida versus Harris. Both of these are Fourth Amendment dog sniff cases. Jardines presents the question whether a dog sniff at the front of a door is permissible absent probable cause. Whether you see dog sniffs of automobiles, of luggage at airports, can the cops, without any probable cause, come up to your front door and let the dog sniff around the perimeter a little bit and see if it alerts, and then use that as a basis for probable cause to get a warrant.
Who thought that was a metaphor, by the way, and not an actual dog sniff?
It is a dog sniff. The second case, Harris, has to do with whether an alert from a dog standing alone is sufficient to justify probable cause, to establish probable cause. Last term, there was a really interesting Fourth Amendment case that had to do with GPS devices and whether, in the absence of any probable cause or reasonable suspicion, officers could place a GPS device on an automobile. The GPS device itself only would track information that would otherwise be publicly available if officers followed you around everywhere you went, and it was settled Supreme Court law that following people around on the public streets and the like and keeping a log of every place they go and what they do is not a search, because it's not there's no protected privacy interests that are involved. Similarly, the court so far has treated dog sniffs as if there's no protected privacy interest, because the only thing the dog alerts to is narcotics, and you have no privacy interests in having narcotics. You may not have known that, but you don't. And so that's the question. What's different about this is they're walking right up to someone's front door, which is the sort of holy grail, if you will, of privacy interests. And so that presents an interesting question. I think, like the GPS case from last term, it was one of my favorite cases as far as how the argument went and how the court came out. If you had followed the doctrine in this area, it seemed like a pretty strong argument for the government that the information being provided by a GPS device is not protected. It's not, you don't have a privacy interest, and therefore it's not a search. All of that changed, and all that doctrine went out the window during oral argument when the Chief Justice asked the government for the lawyer, wait a minute, you could put one of those devices on any of our cars, meaning the justice's cars, without any probable cause, and they could track everywhere we go, and we have no privacy interest in that? And the lawyer for the government had to say, well, you don't have any greater privacy interest than anybody else, and the case was over. So we'll see how the justices feel about dogs being walked up to their front doors. Interestingly enough, last term there was also a strip search case where if you got arrested for some very minor infraction, could you be subject to a strip search if you were thrown in jail? Apparently the justices weren't worried about finding themselves thrown in jail because they had no problem allowing that strip search. Well, again, we'll see increasingly. I think the justices tend to look at these cases from the standpoint of would it impact me or people I know? And we'll see how that turns out.
So if you have your pooper scooper with you, it might be okay or something.
Correct. And then I wanted to just cover a few cases that are relevant to business interests. One is, I'm not sure I'm pronouncing this right, Kiobel? There we go. It has to do with the Alien Tort Statute. It was actually argued last term, and most people thought the question in the case had to do with whether corporations could be held liable under the Alien Tort Statute if they were engaged in human rights violations with foreign nations. So, this case involved Royal Dutch Petroleum, I believe in Sierra Leone, if I remember. Nigeria, thank you. And it was a fairly contested question as to whether under international law there's corporate liability as well as liability for sovereign actors and the like. During the argument, a lot of attention got brought to bear on the issue of extraterritorial application and whether the normal presumption that exists for most laws against the extraterritorial application of federal statutes has any bearing in this context. Obviously, there's some extraterritorial application that's going on here, but what you have is a foreign corporation that was alleged to have engaged in human rights violations abroad, and the justices really seemed to be, several of them anyway, focused on the question of why is this in the United States, and why would Congress have wanted to allow these kinds of claims in the United States. That's a very interesting development, I think, for people who care about litigation under the Alien Tort Statute and holding corporations and other entities accountable for their actions abroad. Most of the kinds of cases you see brought under the statute involve extraterritorial conduct to a large extent. Usually in a corporation that's providing services or other goods to a foreign nation who's abusing its people. And so depending on how the court resolves that question, you could see a lot of the general application under the Alien Tort Statute dry up or be limited. Another case is called Kurtzsang versus John Wiley and Sons. This has to do with the Copyright Act. I'll be really brief on this, but it's actually an interesting question. For a long time, the producers of copyrighted goods have their wish, their deepest desires is to figure out how to control the downstream market for their goods. They can control the first sale, but boy, if they could limit your ability to resell and impose terms on that, that could bring a lot of revenue to them. So being able to figure out a way to control the downstream markets for their goods is something that they are very fond of pursuing. Unfortunately for them, the law has generally blocked that and has for a long time through a doctrine known as the first sale doctrine. So generally speaking, the holder of a copyright can control only the first sale, but nothing more. Under the Copyright Act, however, that first sale doctrine is embodied in a provision, Section 109A, that uses the phrase lawfully, to a copy lawfully made under this title. And that's what it applies to, the first sale doctrine. And the question is, what does that mean? What does lawfully made under this title mean? The arguments in the case go like this. The producers of the copyrighted goods say their products were made abroad. And because, this is going to sound familiar with what I just said, because the Copyright Act doesn't apply extraterritorially, if the products are made overseas and are sold overseas, they are not lawfully made under the title because it doesn't apply abroad. The other side, those that like to resell goods, think eBay, for example, says that's crazy. Why would Congress put a special benefit to control the downstream market for foreign produced goods in the law that doesn't exist for goods that are manufactured in the United States? Because of the textual argument that's there and some of the force that comes with what does under this title mean, the Supreme Court 2 terms ago split 4-4 on the question, with Justice Kagan having recused herself. So they're taking another run at it, again, which seems to be a little bit of a theme today as Justice Kagan works through her various recusal issues. That's a very closely watched case for people who care about copyright. And then the last thing I just mentioned, there are 2 cases, Amgen and Comcast, that involve class actions. And the Supreme Court, over the years, has imposed fairly significant limitations on the ability to certify certain class actions. The concern that seems to exist is that once a class is certified in a case, there's tremendous pressure to settle. And so I think some of the justices have felt obligated to construe various statutes and the like and the rules that are in place fairly stringently to not make it too easy to certify a class. This term, there are 2 cases, one involving the Securities Act and the fraud on the market theory, and one involving the Antitrust Act and damages and how you define damages that present these same questions again. And it'll be interesting to see how the court resolves it and whether, as some might predict, the business interests will come out ahead. But that's an area of civil procedure that the court cares quite a bit about, actually.
Thank you. We're going to turn to you for your questions and comments now, and we'll get you some help in getting microphones. Maria Stella and Dana, if you get their attention, who would like to go first? Who has a first question to ask from the audience? Give us some indication. Yes, sir, over here on the side, right behind you, Maria Stella.
Hi, my name's Fabri Di Piazza. I'm from Governing Works. I wonder if we could return to this question that was brought up at the beginning about Supreme Court power. There is this discussion that the Supreme Court is stepping into a breach that's being created by increasing partisanship. At the same time, the Supreme Court's docket is reducing fairly radically in size. So I wonder if you could discuss that issue.
Well, the reduction's not news, although we did hit a historic low of post-argument cases decided by written opinion. But I think what is new is there's a kind of dialogue between the court and Congress which has ceased. It's an artifact of congressional polarization that in some of the cases David was describing, the copyright case, the Alien Tort Statute case, all the court is doing is saying, here's what I think the statute means. But if you, Congress, have a different view, just pass a new statute. If we get it wrong, just pass a new statute. That's different from a constitutional case where the court has the last word. In this kind of statutory case, it used to be that Congress would routinely, 10 or 12 times a session, override a Supreme Court decision, and that was a healthy dialogue. But since Congress is locked down and can't get anything accomplished, the Supreme Court's power in these areas has only grown, and its interpretation of a statute now tends to be the last word.
You know, one of the interesting dynamics, my own view is that we have a court generally that's as comfortable in the exercise of its own power as we've probably ever had. And that's been true for some time, but I think the more recent changes on the court have only reinforced that. I don't know that that's necessarily good or bad. I just think it's the way that it is. If you go back and look, for example, during the Berger era, you'll find a fair number of statutes being overturned, but you see an awful lot of hand-wringing. The first 5 or 10 pages of the decision, there's all this language about how we recognize that we're the least democratic branch, and we're sorry we have to do this, but now we have forced to do so. And for a long time, you never saw that language. It was just done. And that's true whether it was a left-leaning majority or a right-leaning majority. Again, whether it's striking down one of the acts of Congress under the Commerce Clause, or striking down the Detainee Act, by a more left-leaning court. There was very little concern about the fact that it was the least democratic branch. The first time I've seen it in a long time discussed in an opinion in a significant way was in the Chief Justice's opinion in the Affordable Care Act. And so we'll see what that means for the future. But as a general matter, I still think we have a court that is remarkably comfortable in the exercise of its power.
Who's got another question? Anyone else? I have one for you while people think about it, which is sort of the breakout case of this session. Last term it was easy. Just about every panelist talked about Affordable Care Act. Is there a case that you think we'll be talking about in the same way next year in this term?
I think we've covered 3 of them, and they're all biggies. It kind of depends what they do.
Right.
If they strike down Section 5 of the Voting Rights Act, a law for which people in the civil rights movement bled and died, that would be a big thing. Yep. If they stop public colleges and universities from being able to take account of race in admissions decisions, that would be a big thing. And if they take a significant step on the road to a constitutional right to same-sex marriage, that would be a huge thing.
It's a big term.
Yeah, I agree with that, and it that puts you at least on par with last term, which was a remarkable term. The court doesn't have to resolve all of those issues in those ways, as we sort of indicated. My guess is the one that's most likely to get to a decision that's going to be significant is the DOMA cases. But it's one that once they take it, it's hard not to say something significant about it. Although you certainly could make an argument that says when the federal government is defining who can receive federal benefits, it has its own independent voice, regardless of how states may define relationships, and sort of avoid too much treading on the constitutional question.
Yes, sir.
Tim Ferriss, retired federal worker. There's been a lot of discussion lately about voter ID laws in the states, and a lot of the rhetoric that has accompanied that has been along the lines of voting is a privilege, but voting is a right. Do you think the Supreme Court, in its consideration of these civil rights laws, may consider some of that rhetoric and how that may influence the court? What are your thoughts?
Well, the interesting thing is, and this illustrates exactly what Section 5 does, is that in Indiana, which a few years ago instituted a voter ID law, the court had very little trouble upholding it. That's a non-covered jurisdiction by the Civil Rights Act. In a covered jurisdiction like Texas, the lower courts have come to a different answer, and that really poses, depending on where you are in the country, voter ID might give you a different answer.
I think there's a decent chance. I mean, there's a lot. Not a lot of people aren't following it, but there's a lot of litigation right now going on about voter ID statutes and efforts across the country, and it's certainly possible that one of those gets up to the court on an expedited basis. It's probably not likely, but it's certainly possible.
Well, I mean, Texas, I think, is going to get there pretty quickly, whether
yeah.
they take it or not.
And you know, the last time the court had it, you saw a lot of questions being asked on both sides about the sort of factual support for the assumptions that underlie both sides, and you could see some uncomfortableness on the part of the justices that, you know, while the evidence of significant voter fraud that you know may be the motive behind some of these laws is lacking, so is the evidence in part that there are a lot of people that are going to be affected by it, and then what do you do with that fact? And so if a case comes forward with a stronger record on one of those showings, it might have an impact, I think, in how the court considers it.
I would raise the possibility that at the end of the election date in November, I don't think we'll have a Bush v. Gore again, but we won't have a case like that, but I can imagine a situation where there'll be a fair amount of litigation after the election that, if it's a close election, may again not tell us who the new president is. I'm sorry, who the next president is. You know, for several weeks.
Uh-oh, here we go again.
Well, I mean, some
And she
people are
was
saying
right,
it's going to turn on
and
Florida.
we all know how good she is at predictions. She's already established that. You better write that one down. That sounds like.
If it turns in part on Florida, and Florida has a voter ID law, then it's, you know, it could be Bush versus Gore all over again.
Obama v. Romney, it doesn't trip off the
Doesn't
tongue.
have the same
but-
ring.
Wake me when the nightmare is over. Anybody else with questions? Yes, sir. Hi.
Scott Colburn, Penn State University. I had more of a procedural question about the court. The panel was discussing about different justices have different ways they decide on whether or not to recuse themselves from a case. Are there any recent controversial decisions by any justices surrounding that? And if so, are there any consequences for a justice that might others thought he might have to recuse himself and they refused to do so?
I'll start. One of the more controversial ones in recent times was after Scalia went duck hunting with Cheney. There was a case on the docket where Cheney was a party. He was a party in his capacity as vice president, not as an individual person. And a number of people thought Scalia should recuse himself. He absolutely refused, gave reasons, as I recall. And your question, is there any recourse? No. It's just rant and rave and get, the New York Times to say something.
Which will do a lot of good.
And Scalia will ignore
Especially
you.
for Justice Scalia.
Wait, the New York Times says I should recuse?
Well, in this last term, there was some articles
subscription
written
again?
about the role that, as I recall, that Justice Thomas's wife plays with a conservative think tanker group, and its connection with Tea Party movement and things like that, and the impact that might have had on his views of the Affordable Care Act. And then you had Justice Kagan, who is the Solicitor General, might not have been directly involved, but some people in her office were in the lower court proceedings involving the act.
It's actually a real conundrum. It's a real thought experiment. On the one hand, they get to sit as judges on their own case, right? They get to decide whether they ought to recuse or not, and that seems odd. But it's also hard to know what the alternative mechanism is. It'd be very hard and dangerous to let the others say, no, I'm going to recuse my enemy off this case. Or to call in outsiders. I think there's a point at which, and these are people of great integrity.
You
and
need the
goodwill.
Supreme Court to decide
Yes,
who needs to
Well, and
recuse themselves.
half the cases we talked about up here today, part of our concern is that it ends up with only being an 8-justice court instead of a 9-justice court. So recusal may not be desirable, even though it may be ethical.
Correct.
That's why they don't recuse much, because they it leaves it with an even number, and it's a bad thing.
Math doesn't work. And a final question. We have time for one more. Yes, in the back right there. Dana, if you get the microphone back there, please.
Hi, Elizabeth Leitz. I work at a healthcare trade association. I was wondering, just based on what you were saying about last year being a really big Supreme Court year, and then this coming year dealing with a lot of civil rights cases, do you think that with all this legislation sort of percolating at the state level, and then also you have the ACA, are these cases born out of partisanship that we've seen over the past 4 years, or do you think it's cyclical? Just, we all happen to tend to go to these civil rights cases every so often, or do you have some other theory?
The genesis of the cases that they.
Well, the answer to that might have changed, right? If you'd asked me that question about the healthcare law a year ago, I would have been one who said the arguments that Congress didn't have the commerce power were totally frivolous and partisan, and the motivation for them was not particularly a good one. And 5 justices voted quite strongly to say Congress doesn't have the commerce power. So,
Of course, it was all dicta, so it doesn't count anyway.
so I might have to eat my answer, I guess.
Lift out your shoe.
You wouldn't be the first who's had to have that for. Well, let me say thanks to all of you for joining us today, and I particularly want to thank Kathy Hawk, who is the editor of this fine publication. If you don't get it, you should get it, along with the New York Times and every SCOTUS blog and everything else that our panelists write for. And also to thank Mabel McKinney-Browning, the division director for the Division of Public Education at the American Bar Association. Thanks very much. And then I'm going to ask all of you to join me in thanking this outstanding panel for joining us today.